Ja,
Ja,
ist ja einfach so.
ja.
Ja.
Ja. Ah, da ist es, okay.
Mhm.
Was meinst du, wie viele Leute den erkennen?
Ja, bestimmt nicht mehr.
Noch nie gesehen? Okay, löse ich hinterher auf.
So, welcome again to the third lecture, third session. My name is Thomas Sören, if you know me. We have spoken about information wants to be free as a general principle. And then it's the first exception from that is a trade secret law. Then we had a lecture on special model invented by the European Commission, such as the Software Protection Directive and the Database Directive. Now I have the special pleasure and a real big honor to welcome Guido Westkamp here in our course. He will now start his lecture on copyright law, but not in general. He's talking about the acquis communautaire. Acquis communautaire means the general principles of the ETJ and in the directives and so on. Guido is a very good friend of our institute. He was one of my first doctoral students. He made a marvelous doctoral thesis, summa cum laude, and then he started a quick career with all his knowledge, not only in law, but in foreign languages, in history, and so on, which leads him to the Queen Mary College, where he's now one of the top lecturers in Europe in the area of digital law. It is my special pleasure that he is taking the part in digital copyright laws, the acquis communautaire, and the floor is up to him. He will also speak next week because he has more than 110 slides prepared. So we will finish next week. Remember, we have our Q&A session after this lecture. So you have a separate Zoom data for that. But now I leave the floor to Guido, and thank you for coming.
Thanks so much, Thomas. And thanks also for inviting me. It's a great pleasure to teach this sort of module on copyright law in the context of the digital economy. It is quite a challenge, I have to say. As you can see, it's more than 130 slides. The original version of those slides is 280. But I'm trying to do that within, in this week and the next week. And very briefly, what I'd like to focus on is the more salient topics that we have when it comes to protection by copyright in the context of digitization. So we're going to focus more or less exclusively first on the 2001 directive on certain aspects of copyright and related rights in the information society. Why? Because this is the most important directive that aimed, well, first of all, to harmonize copyright laws across the member states. It aimed to implement the so-called WIPO treaties from 1996. But it also had quite a clear policy objective in those days. And that was to provide copyright owners. And by copyright owners, I don't necessarily mean authors, but the copyright industries with an incentive. And that incentive was to say, we give you very strong rights. And in return, that is going to incentivize you to come up with new business models, such as streaming services, download services, and so on. We can think about whether that kind of incentivization, sorry, has actually worked out. Yeah, whether it was really the music and film industries that jumped at those opportunities. We're going then to look at the exclusive rights that come with copyright. For those of you who are completely unfamiliar with copyright principles, the usual way copyright law works is that, i.e., if you have a factual case, you would first have to see whether there is subject matter that is protectable. And that falls into categories. On the one hand, works of authorship. And for works of authorship, in works made by humans, you need to show that there has been sufficient originality. And originality, in turn, now means the author's own intellectual creation. In a second step, if you have a scenario, you would then consider whether one of the exclusive economic rights has been infringed. So copyright is not like patent law or trademark law, where you have a general use right. It is a bundle of certain exclusive economic rights plus certain moral or personality rights that we're not going to address today. And those economic rights, again, come in two different categories, historically. The first category being clearly the right of reproduction, as the central right that applies. And we're also going to look at how that right has expanded in a moment. And to the right of reproduction historically, there is another right attached, and that is the right to distribute copies of a work. And with that distribution right comes a very important carve-out exemption, which is called exhaustion. So we're coming back to that later. And then we have rights that have to do with the communication of works. And here we will find later on today the central right in Article 3 of this directive, which is the right of communication to the public by way of making available works in an interactive manner. So exclusive rights. Then we're going to move on to consider what is probably the most complex minefield in current copyright law, the whole system of exceptions and limitations to copyright. Why limitations and exceptions? Because clearly there are certain areas, certain users where the monopoly that you get under copyright law should not go as far. So there are certain purposes, from private copying to users in the media, uses for the purpose of parody or pastiche or quotation, and a lot of other uses that may or may not be permitted under the directive. This whole area of regulation is probably the worst part of the directive, because what the directive is saying, more or less, here is a list of potential exceptions or limitations that member states may keep or may introduce, but you must not go beyond. So there is no harmonization there at all. Then we're going to look at technological protection measures. In other words, how technology, the code, can regulate access to works protected by copyright under this directive. Now we're going to do that very briefly. It is overall a rather complex issue because, of course, when I have technology to block access, of course, you always have access. If you buy a book, everybody can read it. If you buy a DVD or if you buy a CD that probably you don't do anymore, you can listen to it. You're not infringing copyright by that. So access is always free. So it is access to ideas, to information, and so on something on which, of course, culture is built. And if you use TPMs as a kind of gatekeeper, as a kind of electric fence around your work, then, of course, you not only protect against the doing of certain acts, such as reproduction, but you are blocking access to the idea underlying the work and the information contained in the work. Yeah. So in other words, in copyright, we have a very clear distinction in every single copyright jurisdiction between idea and expression. It is only the expression, yeah, that is protected and not the idea. Yeah. And then next week, probably we're going to look at the more pertinent issues right now, questions of parody and pastiche and typical referential or transformative uses, especially on platforms, and the link to platform liability under the new directive. Yeah. So if we consider the 2001 directive, and again, you know, we are now in the late 1990s, which is a time that you probably won't remember. Yeah. But the internet had just started, to come about. And what happened in those days was that first there were two treaties, the WIPO treaties in 1996, that were designed to deal with new phenomena on the internet, especially making it available. And that provided the basis for this directive, which was more or less finalized in structure in the year 2000. That came into force in 2001. And if you look at this directive, which you should do, the best way to look at it is in terms of a kind of normative hierarchy, from the strongest form of protection that it grants to right owners, to other, let's say, expressions of a high level of protection. So first, again, we have the code and law interplay, i.e. TPMs. Second, we have a technological ability to control. Of course, I can use a code to block access to a particular work. That is quite important in this context, because it gives me, as an owner of copyright, as an owner of rights, the ability to stipulate terms and conditions. Simply by saying, I will grant you access. And a typical example of a TPM is what? A password. I will only grant you access if you sign up to my terms and conditions that I'm going to put to you. We have a normative expansion as well that we're going to look at in much more detail later today, but especially when it comes to the reproduction right. This covers temporary copying, but exempts certain transient copies. Something that nobody really understands. And we're going to have a brief look at the probably worst provision in this directive, which is Article 5.1. Something that actually nobody really understands. We have a withering away of copyright limitations. The directive tells you in its recitals when you're going to introduce or maintain copyright limitations or exceptions in a digital environment, in an online environment, you should rather not. Or that should be more or less covered by contracts. Direct agreements between right owners and users, i.e. typically streaming, download, and so on. And there is, and really before we start, quite an interesting observation on copyright law and how copyright law is being applied to these new phenomena, and why it creates so many tensions and frictions that legislators have to resolve in a certain way. And that also makes it extremely difficult and extremely complicated. Old copyright is quite easy. It's very easy to understand. I'm a lone author, a genius maybe, but I need somebody to get my work on the market so that I can live with it. So I need an exploiter. What copyright law then does is, in economic terms, to create a kind of artificial scarcity. Yeah, it's a property right that I can transfer. Yeah, the user had nothing ever to do with copyright law. Yeah, why? In the old days, what did you have? You had maybe books, you had maybe records, yeah, CDs and so on, yeah, and all those users were not subject to the control by the copyright owner. In addition, yeah, in Germany, yeah, you have a copyright limitation for the purpose of making copies for private purposes. Yeah, you can resell your books. Yeah, why? Because of exhaustion. Yeah, so in other words, the user never had anything to do with copyright. Yeah, and I think it's true to say that maybe when I was a student, no one talked about copyright. It wasn't subject. It was not part of the curriculum at all. And before Thomas Hearn came to Münster, no one was interested here in Münster. And this really has changed. And this is Niklas Luhmann, of course, yeah. And it leads sort of to a situation where we have to talk about a reduction of complexity. Why? Because we have all these, very different interests, yeah, in copyright law. It's not a linear kind of structure. Yeah. We have interests of authors, we have interests of copyright exploiters, the copyright industry, yeah, which clearly do not have to be the same. But we also have intermediaries, platforms. Yeah. We have institutional users, yeah, libraries, museums, archives, yeah. And everybody wants to have, when digitization came about, yeah, a share of that. Yeah. So it's a much more complex structure, and you can see this on the slide that I'm a bit proud about, but I'm not going to read it out. I'm going to skip a lot of slides, but the slides will be made available to everybody later on, I think. Okay, now let's first talk about the exclusive economic rights. And as I mentioned before, if you are not that familiar with copyright, it's an extremely important insight that copyright law never provided copyright owners with a general right to use the work or subject matter, i.e. a neighboring right, in question. So in contrast to other IP rights, such as patents, or trademarks, where you have use rights, commercial use rights, copyright law has always been given or giving the owner a bundle of exclusive rights. And in the past, those rights were quite separate. On the one hand, again, you had a right to use the work in a physical form, making copies, and distributing those copies, and certain other rights. But these are the two main ones: reproduction, distribution. On the other hand, communication. And importantly, in copyright law, it is, of course, not prohibited, so to speak, to communicate the work. It is only prohibited to communicate the work to the public. That is a major restriction. And this is where today we have probably 120 decisions by the Court of Justice, considering the right of communication to the public in its various guises. And you find the right of communication to the public in Article 3. And that really is the centerpiece of this directive. Member states shall provide authors and also other owners of rights with the exclusive right to authorize or prohibit. It's a right to prohibit. It's a property right. Any importantly, any communication to the public by wire or wireless means, including, and this is the new internet right, they're making available to the public in such a way that members of the public may access them from a place and at a time individually chosen by them. Okay, and the same then applies to owners of neighboring rights, so-called neighboring rights. Yeah, and neighboring rights include the rights of performers, yeah? Actors, singers, and so on, phonogram producers, like makers of sound recordings, film producers, and broadcasters. Yeah? So the key formulation here is actually in Article 3.1. They may access them from a place and at a time individually chosen. Yeah. Now, where does this right come from? It is quite interesting if you go way back in history, yeah, to 19th or 18th century in England in particular. Yeah, there was only one right, and that was a right to control reproductions, to make copies. Yeah, and a right of communication only came about later. And there was a first right of communication, which is referred to as public performance. For example, performing maybe a musical work, a song, in a pub or at a concert, performing a theater play. Inter praesentis. And that may be direct or indirect. Indirect meaning via loudspeakers. That right is not part of the acquis, but there is an obligation under international copyright convention law. And then historically, another developed, that was the right to control the broadcasting of works. And again, here we have a definition that is again based on where the public is in terms of place and time. Yeah. So for a public performance, it is fully simultaneous. Yeah. Same place, same time. Everybody is in the theater. Yeah. For broadcasting, it is of course different places, but the same time. Yeah. And then of course we have the internet, and that created issues. Yeah. So that in other words, here we had a rather novel right that had been developed, first in relation to the 1996 MIPO treaties. And this is where you get that kind of formulation from in Article 3 that tells you it doesn't matter where the public is in terms of place or time. What matters is that it is interactive. Yeah? It is a place and or time individually chosen by the member of the audience, by the member of the public. That in itself created a number of issues that we're not going to cover today. As such, in terms of what is, for example, the difference between broadcasting, linear broadcasting on the internet, and so on. Yeah, but that is really not too decisive for our purposes today. What is decisive? It covers, first of all forms of interactive making available to the public. Yeah. And it led to a lot of uncertainties. I'm going to go through some of the case law with a focus on the right of communication to the public as it applies to typical, let's say, internet technology, yeah, such as hyperlinking, framing, using a work, putting it on a different website, and all that. Yeah, but the foundation of that right is simply to say, okay, every communication to the public, yeah, now infringes. Yeah, the fact that the public is present at different places and different times, that in fact you have all sorts of individual communications, yeah, is now irrelevant. So, in very general terms, and you can see there are quite a few decisions already. There was some older case law where the Court of Justice, said a few words on the notion of a public, but it developed. And the way in which it developed was that the Court of Justice more or less incrementally invented parameters to define what a communication to the public is and what is not. And some commentators have taken the view this is completely erratic and makes no sense at all. Yeah? I would beg to differ. In some cases, yes. In some cases, no. So the more interesting decisions are to the very right. And these decisions start with or include all sorts of, forms of communication, be it by way of a public performance or by way of broadcasting or satellite casting and so on, and or making available. But the Court of Justice doesn't really differentiate between these previously divergent forms of communication. What they're saying is, well, it depends on a number of parameters. It's not a box-ticking exercise in that sense. It is more the application of conditions and criteria by way of a more or less balancing exercise. Now, the most important, or the two most important but interrelated conditions for a communication to take place are: there must be a new public. That is a public that is different from the public that the owner of copyright had in mind when they first consented to the act of communication. And the second condition that is interrelated with that is to say there must be some kind of technical interference by the user. And the user is always the person that is responsible for the act of communication. So that's more or less the starting point. Plus, of course, when we look at the public, it must be a sizable public. So two persons really do not suffice. Where does that come from? The first case is not a case to do with the internet. It's a case to do with using a satellite dish on the rooftop of a hotel in Spain. So in other words, now you can receive free-to-air television programs. And these television programs contained works protected by copyright. And in that case, the Court of Justice took the view for the first time to say, well, we need to make a distinction. Clearly, when my stuff is played or used on television, I've given consent. I've signed an agreement. If I'm, I don't know, in an Oompa band and I play at Helene Fischer's fantastic German Schlager festival, I will have signed a contract to say you can broadcast that. So that's the perspective of the copyright owner. And then the next question that is linked with that new public criterion is to say, of course, in relation to that first, if you like, declaration of will, is there a new public? Have they taken that into account when they signed the agreement with the broadcaster? Therefore, the Court of Justice uses that idea that there is a kind of technical interference as a kind of indication that it's a different public, i.e. a new public. So in other words, yes, okay, yeah, everybody who has a television set and you can receive the broadcast signal, that's the public that the copyright owner actually had in mind, yeah, when they first gave permission for their work to be broadcast. Yeah, but now you come up with a satellite dish. Yeah, so you are deliberately interfering by using technical means. Yeah, so that your hotel guests, yeah, can now watch television. Yeah, which they would have been unable to unless you had put up that satellite dish. So you interfere with the act of communication. Yeah. So new public, and that criterion, which they developed really in that rather marginal case of, broadcasts and so on in hotel rooms, then sort of led to other decisions because it was applied to internet users later on. Yeah, so that's the case. If you want to have a look, feel free. It's not absolutely necessary. Showing in a pub, yes. Yeah. If you show football matches, Premier League in the UK, in a pub, same criteria apply. Yeah. It is a new public, because you interfere. You make it, well, it's a public performance, but you make it accessible, to punters in your pub. It covers any transmission, irrespective of the tactical means or process used. Works made available through retransmission of terrestrial television broadcast over the internet, using a specific technical means different from that of the original communication, you're caught. Again, you interfere. But then we have cases. I'm going to skip a few slides if you're interested. All these cases are relevant, but you don't necessarily have to read them. This is Del Corso, and that is a lovely case where a dentist in Italy had put the radio on so that his patients would be able to listen to the radio. Is that an act of communication? I have to explain that a bit. This wasn't about prohibiting the use of a radio. It was about money. Why? We're coming back to that. Have you ever heard the term statutory license? Probably not. Yeah. So in copyright law, when it comes to rights, we have rights to prohibit. These are the exclusive economic rights, but there are areas of copyright law where that doesn't make sense. And in that case, the right to prohibit, for example, by way of reproduction or communication, is restricted so that the owner of copyright cannot prohibit, but they get money. Hence, a statutory license, a permission that is written in the statute, but money is paid, usually via a collecting society. And in this case, of course, certain copyright owners said, this is another act of communication to the public. Usually, a broadcaster may, of course, play music. Nobody can prohibit that, but they have to pay. Now, this is a secondary use. This is not a use at home, they said, which is free. Because you pay for it, of course, via broadcasting fees and so on. But this is in the context of a dentist practice. And there the Court of Justice said, this is not a communication to the public. And this is where things got tricky a bit, because they said, the audience, patients in a dentist practice, they're probably, too passive. They're not interested in enjoying, what is coming out of the radio, which I find questionable. Yeah, because of course, if you play music, yeah, if you have somebody like myself who is really afraid of dentists, yeah, that can make a lot, of course, of difference. Yeah, for example, if you play soothing music, yeah, in order to enhance, yeah, your profit. Yeah. So in this case, the Court of Justice said, you know, this is about the profit-making nature of the activity. Yeah, running a dentist practice and letting the radio play. Yeah, that was decisive. I said, this is, in fact, you know, this is insufficient. Yeah, but in another case, decided the same day, phonographic performance, they said, well, that doesn't apply where you provide guests in a hotel. In this case, in Ireland. Yeah, in Ireland, bed and breakfasts and so on are permitted, yeah, expressly under the copyright law to use radios or televisions, etc. Yeah, this is to foster the Irish tourism industry. And here the Court of Justice said, no, you know, that is an act of communication to the public, and hence you need to pay for it. Okay, so all these cases had nothing to do really with new technology or with the internet or with digitization. And that changed when the very first case concerning internet technology came along. And that's a really, really important case. Svensson. Yeah. In Svensson, the key question was whether the use of a clickable link, i.e. a hyperlink, in itself can constitute A, an act of communication, and B, whether that act was an act of communication to the public. And when you look at hyperlinks, there is a very old decision by the German Supreme Court from 2001, where they said, well, a hyperlink does nothing. Yeah, a hyperlink is neutral. It is the user who would click the hyperlink. Yeah, and besides, if it was in the remit of the copyright owner's control right to prohibit hyperlinks, of course, the whole internet would break down. The Court of Justice then came up with a rather different theory. And they said, well, first of all, we need to look at the notion of communication, and a communication means a transmission of something. So if you have a link, if you place a link to another website, yes, then there is, you as the person setting the hyperlink, yeah, you are fulfilling the conditions for somebody else to click it. Yeah, that is a transmission. Yeah, why? Because you are now giving users direct access to a protected work. But then, yeah, so it's two branches of that reasoning. It is everything you do now is a communication. Yeah, because everything you do is a transmission of a work, even if that transmission would happen later. Yeah, and even if it is instigated by a third party, i.e., by another user. Yeah. However, as we've seen before, yeah, you need to show that there is a new public. Yeah. And this is where the Court of Justice doubted, I think, its own conclusion. As they said, in the circumstances, it must be observed that making available the works concerned by a clickable link, yeah, does not lead to the works in question being communicated to a new public. Yeah. That in itself makes a lot of sense. Yeah. Why? Because in principle, when we talk about copyright law, if there is a link to another website, yeah, and my work is on that other website, and I don't like people linking to it. What can I do? I can simply remove it. Yeah, it is still in my control. Yeah. So the link would go nowhere. Yeah. And therefore, no problem at all. Yeah. But this was the first case, if you like, where the Court of Justice sort of got entangled a bit, I think, in deciding that more or less everything you do is an act of communication, which is debatable. And then to say, yes, but there's no new public. Yeah, because if I've given consent for my work to be used on the internet, yeah, if I put up my work, let's say on my own website or with my consent somewhere, then the link does not generate a new public. Yeah. Why? Because the whole internet now is the public. Yeah. And that is different from cases where you can make a distinction between guests in a hotel and typical, let's say, television recipients. Yeah. So if the free initial communication disappears, then an authorization becomes necessary. Yeah. If the work is protected, for example, by a technological protection measure, yeah, then you can't use a link to bypass that. Yes, please.
Is there like a distinction between private links, which only the people that have access to the link can like have the content of the link, and a link that is made for the public?
I don't have a straight answer for that. It's a very good question, I think. According to the Court of Justice, in my view, as long as you maintain control over your work, it doesn't matter. Yeah. So if the link itself is accessible to everyone, that's fine. If it is accessible to few people, that of course is fine as well. Yeah. So say it wouldn't really make a difference. Yeah. As long, and we shall see later why, as long as somehow you have control over where your work is, and you are still able to remove it. Yeah. But the key conclusions here is to say, okay, everything's a transmission, therefore a communication. B, it is not a new public. The whole internet is the public. That's fine. 3, that doesn't apply where you have applied, or where the owner of copyright has applied TPM's technological protection measures, such as a paywall. Yes, please. Yes. The answer is no, because this was just the first case. I'm coming back to that now, actually. Yeah. Yeah, and this is the German decision, Paperboy 2001. Yeah, where I said a link is neutral. Yeah, it has to be neutral. Yeah, because same applies in the context of framing videos. Yeah, because again, probably if the original video is removed, you can't frame it anymore. Yeah, and there is a major difference that we'll see later with cases where you simply copy a work from one website, and then use it on another website, i.e. not using links, so to speak. Yeah. And then came, and this really is a strange case, GS Media. GS Media was a case about links, hyperlinks, that directed users to, I think, an Australian website. And on that website were photographs of an adult nature, meaning they belonged to Playboy. Yeah. And Playboy said, you can't do that. Yeah. And here the Court of Justice started further differentiations. Yeah. And basically said, well, in fact, on that website, And this is the major difference to the Swenson and Bestwater cases. Yeah. Somebody had uploaded those images, those photographs, yeah, without consent by Playboy. In the other cases, you had consent. Yeah, that was more or less their own copyright works and so on. That was fine. Now this was unlicensed. Yeah. So here, the whole new public theory doesn't work anymore. Yeah. Why? Because we've seen in all these cases concerning a new public, yeah, there had been some kind of initial consent. Yeah. I've signed some kind of agreement to say, again, you know, you can play or you can broadcast my performance on air and so on. Yeah. But now the situation was nobody had consented. Yeah. And this is where, and this is really, really important when it comes to platform liability, because here the Court of Justice sort of set the scene and said, okay, usually if we apply this whole new public criterion, yeah, that's prohibited. You cannot link there. But instead, they were trying to differentiate further. And basically said, well, it depends on the knowledge, yeah, of the person or entity that is responsible for that link. If you are a private user, you do not know if the stuff that you're linking to has been licensed or not. Yeah, that's very clear. Yeah. So in that case, there is no infringement. If you are a commercial entity, if you're doing this for profit, then, however, there is an assumption why you can check. Yeah. So in other words, you should have the ability and the capacity to check whether what you're doing, if you are linking, let's say from your own commercial website to another website, whether that link goes to somewhere that has actually been licensed. Yeah. If you don't do that, you infringe. Yeah. If you are doing, everybody who's doing that linking, yeah, for profit, you need to rebut the assumption that you have knowledge, and you can't do that. Yeah. So now the decisive factor is not new public. Now it really is for profit, but it's linked to knowledge, yeah, rather than, if you like, the doing of the act as such. And this immediately led to the first case, which was absolutely important in the context of the new rules on platform liability. Again, for those of you who are not that familiar with recent developments in copyright, but you will probably have seen it in the press that there is a new directive, and Article 17 of that directive makes providers of services such as big platforms such as YouTube, yeah, directly liable, yeah, for acts of communication to the public, acts of making available by their users. Yeah. And that, of course, and we're going to look at that next week. But one of the first cases that led the copyright industry to say, well, of course, you know, we think there should be direct liability was FilmSpailer. And FilmSpailer is a device that allows users, yeah, to access, I think it was, I don't know, football matches and so on various shady, funky websites somewhere. But it was nothing more than a device. Yeah. And the Court of Justice said, it doesn't matter. Yeah. If you are linking, if you are allowing users to link to illegal content, you are, and that is the decisive issue here, you are making those works available as a manufacturer of that device. So it's not aiding or abetting. It has nothing to do with knowledge. Yeah, it's simply looking at what is this particular device doing. Yeah, and that device allows you to access films and sports and so on. Yeah, from dubious sources in different countries. So it's more or less, it's a collection of hyperlinks. Yeah. And the same applied in Stichting and Ziggo, the Pirate Bay. Do you know what the Pirate Bay is? Have you ever used illegal music sharing services? No. Probably you don't have to do it today anymore. But the Pirate Bay was a well-known sort of file sharing, not website, file sharing software. Yeah. So you would download it and then you would have access to music that was stored on other people's computers that you could download. And in that case, the Court of Justice said, well, you know, if you are offering a service like that, that is like in Filmspeler. Yeah. And Filmspeler is for profit. So it's like in the other case. Never mind. So this for-profit criterion now is completely decisive, but we need to look a bit at what they are doing. And they basically said, well, you know, in such a case, yeah, an evil file sharing website, yeah, you are directly liable, yeah, under Article 3. That is really, really important, because in doing that, yeah, the Court of Justice, at least for file sharing sites or file sharing software manufacturers, removed national systems of liability, yeah, that were unharmonized and still are unharmonized in certain areas. Yeah. Meaning, of course, if you look at German law, if you look at UK law also, you know, that would be a matter of saying, you know, this is vicarious liability, or this is aiding and abetting something, and you need a particular kind of knowledge for it, which you can find. But it's very different to say, you are the perpetrator, you are the direct tortfeasor. Yeah? Because if you are a direct tortfeasor, you are liable under copyright law, not only for damages, but for an accounted profit or for a hypothetical licensing fee and so on. So in that case, the whole business model doesn't make any sense anymore. So this then led to Article 17 of the new directive 2019, copyright in the digital single market. Clearly this also exceeds the previous, still applicable, safe harbor provisions, as some said, under Article 14 of the e-commerce directive for hosting services. But again, up to here, this only applied to really, you know, evil, let's say, file sharing website. But it was really important for Article 17. And then the latest case concerning the right of communication to the public. This sort of goes back again to the notion of a new public. And again, it's a pretty straightforward case. That was about a student from a public school in here, not Rhine-Westphalia, who for her Spanish class had written a paper and thought, you know, this is about Cordoba. So I go to the internet and copy a photo of Cordoba from somewhere. And unfortunately, it was, I think, a professional photographer who found out that this was now available from the school's website and therefore sued the state. Hence, it's the Renkoff, who is the photographer, and the state of North Rhine-Westphalia that are the parties. And this is now different. So what happened here was, of course, you click again on save image, and then you put it on your website. Or actually on the cover of your student paper, which then is put on the school website. And that, the Court of Justice said, is absolutely different from cases such as hyperlinking, such as framing. Why? Well, first of all, this involves a reproduction, clearly. Second, there is necessarily now a new public. Yeah, that wasn't quite clear. But here the Court of Justice said, well, because it is a reproduction, you interfere. Yeah, this is like, you know, you make a copy in between. Yeah, so now, yeah, it is no longer, yeah, the whole public on the internet, i.e., everybody who can access it. Yeah, this is a different kind of public. Yeah, so there is a kind of interference in copying the photograph. So this amounts to an act of making available, yeah, communication to the public. A lot of people, including myself, have criticized that and basically said we need a kind of de minimis provision or a de minimis rule in copyright law. Why? Because, well, first of all, it's very close to, you know, certain educational limitations or exceptions. Second, you know, you don't compete. Yeah, you don't really take anything away from the original photographer. So really, this is just about making money. And there are a lot of cases where you can actually see this is not about sort of defending copyright, yeah, but defending, let's say, unfair competition. It is about making money, yeah, for users that have more or less never been within the remit of copyright control. So this is where we are now in relation to communication to the public. There are, again, a number of further cases. This is really happening every 4 weeks. Yeah, that national courts thing, we don't know. Yeah, what you need to take home, perhaps, is that on the one hand, of course, the application of copyright rules can be dangerous. Yeah, because it is clear that the whole internet, yeah, is built on something that may or may not be protected. Yeah, so prohibiting hyperlinks, yeah, and other technologies, yeah, this is something you need to be very, very careful about. And this is what the Court of Justice tried to do, because they said, well, according to our own jurisprudence, it is a transmission. We cannot get out of that. But then we move on, yeah, to a further limit to say, oh, to the public, a new public, maybe not. Yeah. And then saying, okay, in that case, yeah, nobody is really liable, but there are a few exceptions. Yeah. What this has done, especially when it comes to platforms, devices, and so on, is to provide the foundation later on for the whole lobbying in relation to platform liability. And platform liability means predominantly YouTube, yeah, where the copyright industry was industries, that's music and film, yeah, predominantly was saying, you know, there is a value gap. You as YouTube make money, yeah, because you can rely on a safe harbor, yeah, as a host provider, yeah, and that needs to change, and it did change, yeah, when the new rule was introduced that also not only evil file sharing platforms, but also big commercial platforms such as YouTube and others, yeah, will be directly liable, will incur direct liability as a tort under Article 3. Okay, I will briefly talk about the right of reproduction, but maybe just to put it in context. The right of reproduction as such has nothing to do with the right of communication, at least historically. Yeah? Again, from an economic perspective, you know, this is the right that you can transfer, you can give to your printer, yeah, and they will print books, distribute books, and make money, yeah, for you, for your benefit as an author. When it comes to internet users, things are different, because clearly every time you upload something, clearly every time you download something, you will create a copy. Yeah. And in such a case, that would mean if there would be an unlimited right to control the making of copies, then the copyright industry would control the internet. Yeah. And it came as far as that. Yeah. So usually when we look at, you can make a fantastic argument to say that copyright law would only govern permanent copies. Yeah? A permanent copy, for example, being a photocopy. Yeah? Do you still make photocopies? Do you even know what that is? And the reason is, you know, I create something that I can take away. Yeah, it's a substitute for the original. Yeah, when I'm on the internet, when I'm using something online, etc. Yeah, then I cannot do anything with those copies. Yeah, and a lot of those copies are temporary. I don't know if you covered that in relation to software last week. Temporary copying. No. So there are different ways of dealing with that. I'm being very brief here. But when this directive was made, there was a provision, first in the software directive that was a bit different than in the database directive, that said it's every temporary copy is covered. Yeah, and that was the acquis. And that was then used in this directive, the 2001 directive, and applied to all kinds of works. However, and this comes from the European Parliament, I'm usually spending at least 45 minutes with my students to try and understand what all that means. What this directive is doing is to say, we cannot prohibit browsing the internet. Yeah? So we need an exemption from the right of reproduction, from the right to control temporary acts of reproduction. Yeah, and this is what you have. Yeah, I will leave it with you. You can take it home and think what on earth this is supposed to mean. Just a few words. Transient copies are not temporary copies. So there must be a difference. These need to be an essential part of a technological process. This means browsing, downloading something on the internet. But then, yeah, the sole purpose of those, we are talking about copies that last for milliseconds and that you cannot control as a user anyway. A transmission in a network between third parties by an intermediary. Yeah, that is totally unnecessary because that simply refers to the e-commerce directive and the safe harbor provisions or a lawful use. Yeah, so it's conditioned on a lawful use. So what is a lawful use? Answer, nobody knows. Yeah, is it a license use? If it's a license use, I don't need an exemption, and so on, and which have no independent economic significance. And this is really, I could talk about this in a bit more detail, but then I would really veer off. And but this then, so if you can see, it's an exception to a rule that comes with a re-exception that comes with yet another exception and ends in a re-exception where something has economic significance, which makes no particular sense at all. The case in which that was considered was Infopack, which is not a very good decision. And probably the Court of Justice would not come to that conclusion today. This was really about the question of whether if you use a scanner to scan pieces from magazines and so on, trade magazines, whether that would be a temporary copy. Yes, the scanner makes a temporary copy. Yeah. And whether that would be exempt under Article 5.1. And here the Court of Justice said, no, this has independent economic significance. Yeah. Mixing up a few things, perhaps. Yes. So up to here, if you have authorization, that's always the starting point. Yeah. Some kind of consent. Yeah. Then typically the Court of Justice looks at, is there a new public? Yeah. And then you look for criteria or indications. Yeah. Typically a new public, yeah. For example, a satellite dish, but also cases, yeah, where you use a new technology. Yeah. So for example, taking something from a broadcast and then uploading that to the internet, that would absolutely create a new public for that purpose. Yeah. Linking, framing, yeah, probably not. Yeah, but after G is media, yeah, there was a discussion really in academic literature on the whole notion of, has there been an implied consent? Yeah. So can you imply some consent simply from the circumstances? And the answer is yes. There was a lovely decision by the German Supreme Court, the BGH, in I think 2009, on the use of paintings by a German artist in the context of Google image search. And in that case, the German BGH simply conclude to say, this is like an offer to the world. Yeah? If I put copies of my paintings on my own website, yeah, then I more or less invite the entire world to view that. And I also invite typical internet technologies, such as Google image search, yeah, to apply. And if I don't want that, then I remove it. Or, yeah, I use a kind of technological protection measure, yeah, in order to decide who can and cannot access it. Yeah, I thought that was a fantastic decision. Yeah, it was really based on contract law. Yeah, with the effect to say, okay, then we don't have to put it before the Court of Justice, because of course contract law isn't harmonized, but it would not. BGH would not be able to come to that conclusion anymore. Yeah, so it's very clear what Google image search is doing is it is a transmission, but then it would depend on perhaps other factors. Yeah, so it's become a bit more differentiated. Where there is no authorization at all, yeah, then it's a matter of knowledge and exculpation. Yeah. So if you're a private user, perhaps yes. But again, if it's done or in the cost of a for-profit entity, yeah, then there is an assumption of knowledge. And if there is an assumption of knowledge, you can rebut it, but in reality, you can't. Yeah. Ziggo and Filmspieler, yeah, these cases basically said, you can also be liable for something that simply facilitates certain later acts of communication of other users, of copying by users. Yeah. However, it does not give a clear answer on let's say, hybrid platforms such as YouTube. Yeah. Why hybrid? Because you have legal stuff and you have illegal stuff on YouTube, and hosting services and Article 17. So that really is a completely different matter. But it really was the starting point of the whole debate to say, fantastic. From the perspective of, in particular, the music industry, the answer was, here you have it. Yeah. Everybody is liable for whatever their users or their customers are doing. Yeah. Okay. So up to here, we have 25 minutes to cover copyright limitations. So I think we've already seen that the application, let's say, of these ancient notions of exclusive rights under copyright has led to a highly differentiated system. It gets a bit more complex and complicated when we turn to copyright limitations and licensing structures. And the way it works under this directive is, you can see in the recitals, yeah, really we don't want exceptions or limitations to copyright. Yeah. Why? Because again, that idea of, let's say, user rights, yeah, in the late 1990s, that of course stands again this whole idea of a high level of protection. It's all in the recitals. Yeah, feel free to read it later on. and to come up with their own business models. Yeah. So really, the European Commission in particular then thought, probably, let's be very cautious, yeah, as a member state, to introduce exceptions or limitations that provide too much freedom for users. Yeah, this is something that, you know, when we are expecting the music industry or the film industry to come up with all these fantastic new business models, that will all be done privately. Yeah, based on contracts, terms, and conditions. So how does it work? If you look at Article 5 of the directive, which you should, you will see it is very lengthy. In other words, it's a completely unsystematic enumeration of all kinds of possible exceptions or limitations. I'm going to explain the distinction between exception and limitation in a moment. But the important point is that, of course, there are very, very different purposes for which the legislator may introduce, let's say, more freedom. Yeah. Second, if you look at the traditions of copyright laws between member states, there are no two member states that have the same list of exceptions or limitations. Even between countries like the UK and Ireland, even between countries like Germany and Austria, or Germany and Switzerland, things are totally different. Yeah. Now, in terms of terminology, when we talk about an exception is something that comes for free. Yeah? Because this is where the legislator is saying there should be no copyright, should be no control of the copyright owner in certain areas that are relevant, in particular for fundamental rights. Yeah? Typical example, yeah, the use of hot news in the media. The right to make a quotation, the right to parody a work, or the right to make a pastiche or caricature. Yeah? And then we have, let's say, exceptions that are becoming limitations. And for a limitation, payment must be made. That's the terminology that is used by the EU lawmaker. Yeah? A typical example is the limitation for purposes of private copying. Yeah? So the fact that you can make copies in your home, etc., for private purposes doesn't mean you do not pay for it. Yeah? You pay for it as a consumer via a so-called levy scheme. Yeah? In the old days, blank tapes and maybe photocopying machines and things like that. Today, even laptops. Yeah, and that money, of course, goes to a collecting society, and the collecting society pays this out to authors and also others. So, Article 5 itself is providing member states with a list of copyright LNEs, limitations or exceptions, and they can pick and mix. However, you cannot go beyond that. Yeah? And next week, when we're talking about the Pelham case, the Kraftwerk case, which is my favorite law case of all times, because it's now pending, you will see that this really makes a difference. Yeah? So, Article 5, highly unsystematic. Yeah? It's really sort of, it's a concoction of what you find in different national and member states laws, and you can see it. Yeah. So it was added at the very last minute, and yes. And a lot of debate, and this is really where things have changed over time. What is important here is the three-step test. And if you've never heard about the three-step test, it is the central debate in relation to how copyright law should function in a digital ecosystem in the last 20 years. The exceptions and limitations provided for shall only be applied in certain special cases, that's the first step, which do not conflict with a normal exploitation of the work. 2, and do not unreasonably prejudice the legitimate interests of the right holder. And there is a lot, as you can imagine, of debate on the function and the legal character of that rule. Is it addressed to the member state? Can courts use it? Is it an element in national copyright laws? In some countries it is, in others it is not. And how do you go about it? I cannot go into too much detail here, but you can see this talks about a normal exploitation. So, for example, if we have, let's say, and fictitiously, a provision that says a university library may digitize books or journal articles from their collection and make it available to the whole university. What would happen is that the very minute this is made public, the association, a fictitious association of academic publishers, would be jumping up and down. And the argument in a case like that, to provide, let's say, libraries and their users a better service and better access, would be to say this is a conflict, or this is creating a conflict with a normal exploitation, because as academic publishers, and you all know that, if you think of big academic publishers, they have their own businesses, and those businesses are not based on a copyright exception or a copyright limitation. They are based on contracts. If you want to have access to Westlaw, you need to sign an agreement, or your university needs to sign an agreement, and they will then dictate, the terms and conditions of what you can use there. So as soon, as a legislator, and this has happened in the past, but I'm not going into too much detail here, just to show you the structure of the conflict and the argument. In that case, the typical argument is always to say, well, that creates a conflict with the normal exploitation, because even a future exploitation, by way of, let's say, a download service or, and so on, this is our market. And the legislator cannot enact a provision in copyright as a copyright limitation that would even extend to future markets or markets that are unknown at the time. And in that case, of course, you have a problem clearly with freedom of competition and so on. So this is why Article 5.5 is so important, but we cannot really go into too much detail. It's quite a convoluted debate. Private copying, that was a major bone of contention. Because the industry was saying, well, look, if we have direct business models, downloads, etc., then we don't need private copying anymore. So if you think of Spotify, everything is there. Nobody needs to make copies for their private purposes. Nobody uses tapes anymore. Nobody uses blank CDs anymore. Still, it's still there. There are two subparagraphs here. The second one is the more important one for our purpose. The first one is about photocopying and so on. For ends that are neither directly nor indirectly commercial, member states may permit the making of private copying on condition that the right holders receive fair compensation, which takes account of the application or non-application of TPMs. So if you apply TPMs, then of course you already make money on the basis of that, because you usually then have a direct contract. Yeah. If not, you would usually get your money from a collecting society. Yeah, in this case, under the levy scheme. Compensation must be paid. It's fair compensation. Yeah, and this is why in the UK we do not have a collecting society. Yeah, and there is no private copying exception or defense. Yeah, it was introduced, but the fact that there was no compensation scheme meant that the whole new provision was then killed off by the High Court later on. Yeah. Libraries, museums, and archives in respect of specific acts of reproduction. Yeah, the way it works in Article 5, you have Article 5.1. That's the strange transient copying exemption. 5.2 that applies only to the right of reproduction, and 5.3 applies to the right of reproduction and the right of communication to the public. Yeah. So here we have, again, you can see the spirit behind it. It's to say, okay, we need to give libraries, museums, archives, also educational establishments, maybe a bit of the advantages of digital technology. So they should be able to, let's say, make copies for archiving purposes, preservation purposes. Yeah? And this was done in most member states. If you are interested, there are clearly links to the so-called Orphan Works Directive. Orphan Works meaning works where the owner of copyright cannot be identified, and the text and data mining exception that maybe I'm going to say a few words on later, but it's probably coming back in the context of this program and the context of AI. Yeah. So for non-commercial purposes under the new directive, and less so for commercial purposes, which was really meant as a way of allowing research and allowing research in certain privileged institutions, in particular, like libraries, university institutes, and so on. Yeah. Yeah.
We are talking next week on AI and data mining.
Yeah.
Exceptions, so therefore it's very important for our audience to understand that we are coming back to that exemption, which is really a crucial point for every discussion on the AI.
Yes, absolutely. It is quite interesting because it wasn't made for AI. But today the AI industry is saying, we need to get training data, and then we can mine those training data. Yeah. And ideally, we should be able to do that also for commercial purposes. And what is being discussed, of course, is, should there be still a right to prohibit, should it apply at all? Should it be an opt-in or opt-out approach, and so on. So this is what I just talked about. Value-added services, if you like, if you have, of course, a library or a museum, and they are running their own system of allowing users access. It's interesting if you compare it to, for example, Switzerland, where you can do that. In Switzerland, I think the Swiss Federal Court has said, well, you can, as a university library, you can allow your users to download journal articles, excerpts from textbooks on a USB stick. You can allow them to email them to their own account. Yeah, that would be entirely unimaginable, I think, in any EU member state. Yeah, under this directive. Generally, what about copyright defenses, copyright limitations, copyright exceptions? There has been, again, a lengthy debate on how to interpret copyright limitations or exceptions. And there is one school of thought, which is the more traditional copyright lawyers that would hold, well, it is an exception, and an exception always needs to be interpreted very narrowly. There are a few academics that have shown that this, of course, is nonsense. And what we are seeing, or have been seeing for quite some years now, is, and this is really, really important because it's coming from a completely different direction, that in some cases, the Court of Justice has started to talk about the need to always balance the interests. And it goes back to a decision on copyright enforcement, yeah, and the role of privacy and data protection, where the Court of Justice said, well, you know, the fact that it's copyright, the fact that it's a property right does not mean that you can enforce it without any kind of restriction. Yeah, you need to balance. Yeah, and that notion of balancing is now repeated in more or less every single decision on copyright. Yeah, so that idea, you need to interpret it strictly, narrowly, has been killed off. What it started with, and were in fact a couple of cases that look at purposive interpretation. Yeah, so you look at the purpose of the exception or limitation in question. Yeah, and this is where the Court of Justice really had to come up with, let's say, a new structure of, dealing with copyright cases. And okay, I have 5 minutes. This should be the end for today. But it's really 3 central cases, and they all came from Germany, and they all came, yeah. Or let's say they all came from Germany, and there was probably a reason why they came from Germany, because here the Court of Justice, the Supreme Court in Germany, basically said, look, we have all these strange cases on, where somebody's raised copyright, yeah. How do we go about applying fundamental rights, in particular, freedom of expression, yeah, and its various sub-guises, freedom of the media, freedom of opinion, and so on. And the first case in which the Court of Justice, and I'm coming back to that next week because I can show you the image, but that's Deckman. That's a case on parody, yeah, which is a bit of a strange case. But in that case, the Court of Justice said, yes, you need to balance. Yeah, it's not simply a matter of defining what a parody is. Yeah, you need to take into account, yeah, what the use of a parody does to the person of the author. Yeah, so this was really no longer a copyright issue. Yeah, and then we have these 3 cases, and I'm going to talk about the Kraftwerk case because I love it so much at length next week. But the Spiegel Online and Funke Media cases are quite important. Funke Media is a really, really strange case because it's related to the so-called Afghanistan papers. And that's reports about the German Bundeswehr and what they did in Afghanistan that were leaked, I think, by German media, and where the German Ministry of Defense said, these are public reports, but you know what? Yeah? These are protected by copyright. There's nothing you can do with it. Yeah? The second case was even more enticing. That was Beck, Volker Beck. Yeah? Do you know Volker Beck? And you? Okay. Volker Beck used to be quite a prominent politician from the Green Party. And Volker Beck, way back in the late 1960s, of course, he was extremely left-wing, and he wrote a piece on that it's okay to have sex with children. Yeah, and that was leaked years and years and years later by Der Spiegel. Yeah, and these were the 2 where the Court of Justice really had to deal with the question: what is behind? Yeah, that simple enumeration of purposes, yeah, in Article 5. Yeah, is there more to it? Yeah, can national courts simply apply their own understanding of fundamental rights? Answer, of course, no. Yeah, autonomous interpretation. However, these 2 cases basically said, yes, the way that copyright exceptions and limitations must be interpreted is through the filter of fundamental rights, meaning the EU Charter on Fundamental Rights. Yeah. So that is in the vicinity or in the remit of interpretation by the Court of Justice. What they did not, or where they rejected any application of fundamental rights, way back in 2000 and when was it? 19, is that right? Was the Kraftwerk case, because here there was no limitation or exception applicable for music sampling, and that's something we will cover next week. Thank you very much, everybody. I think it's
the tradition, and nobody's allowed to speak here for 1 hour and 30 is long, unless he gets a gift, and that is a typical Georgian red wine. I hope you like it, although the situation in Georgia is not very well. Taste it, perhaps it's better than the political situation in Georgia now.
Thank you so much.
We see each other next week. Then he is speaking not for 1 hour 30 minutes again, for 45 minutes, and then we come to the topic of protection of AI and how AI fits into the scope of copyright law. So see you all, you four, the others who are missing today, apparently sick. And thank you all for listening. We will see each other in the Q&A session within 10 minutes.
Okay.
So thank you. See you in the Q&A session.